Week 2, Discussion 2, AU Hospitals Defendant Position Regarding Impermissible Uses and Disclosures. Kathy E. Thompson, HCA 322, Healthcare and Ethics and Medical Law. Instructor Lilia Chavarria, July 12, 2017. Statement of the ethical and legal issues. AU Hospital Defendant is being sued by Jennifer, plaintiff, arguing that AU Hospital impermissibly disclosed protected health information, PHI, in response to a subpoena that was issued, which was not accompanied by a court order. It is AU Hospital's position that the patient's information that was provided pursuant to the subpoena for medical records was satisfied both ethically and legally. AU Hospital received a subpoena in request of medical records for the plaintiff, Jennifer. AU Hospital's Medical Records Department responded to the subpoena in accordance with the standard hospital procedures for providing medical records for the purpose of legal proceedings. AU Hospital's Medical Records Department also responded to the subpoena within the time frame prescribed by the court. After complying with the subpoena request for the medical records of the plaintiff, Jennifer, AU Hospital Defendant was subsequently notified that they had provided a copy of the plaintiff's medical records and were not in compliance with standard PHI. It is AU Hospital's position that the plaintiff's medical records were provided legally and ethically. Therefore, the plaintiff's privacy rights were not violated. Statement of AU Hospital's argument. Number 1, when the subpoena was received by the Medical Records Department for AU Hospital requesting the medical records of the plaintiff, Jennifer, there was nothing unusual about the subpoena that would have alerted the personnel in the Medical Records Department to question its legitimacy and validity. Statement of AU Hospital's argument continued. Number 2, the medical personnel in the Medical Records Department, who typically comply with the medical records requests, followed all the proper procedures and guidelines for complying with subpoenas for patient medical records. Number 3, the medical records subpoena not being accompanied by a qualified protective order did not negate AU Hospital's legal responsibility to comply with the subpoena for the plaintiff's medical records. AU Hospital's defendant's argument on all 3 key issues. Number 1, the medical records subpoena was a standard request and there was no reason for the medical records personnel who responded to the request to otherwise question the legitimacy of the subpoena. AU Hospital has an electronic medical record system, EMR. EMRs provide extra safeguards of security and patient confidentiality because passwords are required for medical record retrieval, citing First et al. 2013, allowing the hospital to be able to maintain accurate records of what patient records were retrieved, when they are retrieved, and by whom. AU Hospital's defendant's argument on all 3 key issues continued. Number 2, the medical records personnel at AU Hospital complied fully and in accordance with all of the hospital's legal guidelines and procedures in its response to a subpoena for medical records. AU Hospital has a thoroughly designed EMR system, when utilized to its fullest extent, provides the means to combat litigation, citing Freeman 2009. Any medical record subpoenas are responded to always with the patient's privacy as the highest priority. AU Hospital's defendant's argument on all 3 key issues continued. Number 3, the medical records subpoena not being accompanied by a qualified protective order did not negate AU Hospital's legal responsibility to comply with the subpoena for medical records. Finally, it was not the responsibility of AU Hospital to ensure that the plaintiff had been properly notified that her medical records had been requested and to secure a qualified protective order upon the issuance of the subpoena. When a subpoena is issued, you do not need anyone's permission and you can ask for whatever you want to C, without any opposition from the plaintiff, citing Block and Boone, 2006. Therefore, AU Hospital was issued a valid court subpoena and was required to produce the plaintiff's medical records within the time frame allowed by the subpoena or risk being held in contempt of court, citing Block and Boone, 2006. Thank you.